There is a moment that catches millions of older Americans off guard. One day you are handling your own money and medical care just fine. The next, an illness, a fall, or a hospital stay changes everything overnight. And here is the hard part. If the right paperwork is not signed ahead of time, even your closest family member may be locked out of your bank account or your doctor's office. 3 simple documents can prevent that. One of them protects your money in a way most people completely misunderstand, and I will show you exactly how it works. This matters most if you live alone, manage your own finances, or want a spouse or adult child able to step in during an emergency. It also matters if you have never signed these papers, or signed them so long ago you cannot remember what they say. Let's start with the document that protects your money, the Durable Financial Power of Attorney. This is a legal paper that names a person you trust to handle money matters for you. Banking, paying bills, dealing with insurance, managing property. That person is called your agent. The key word is durable. A regular power of attorney can stop working the moment you become unable to make decisions yourself. A durable one keeps working precisely when you need it most, if you become sick or confused and cannot act for yourself. Here is why this matters so much. Many people assume that a husband, wife, or grown child can automatically step in and pay the bills if something happens. Generally, that is not true. Your bank does not know your family. It knows your account. Without legal authority on file, the bank may refuse to let anyone touch your money, even a devoted spouse. Picture this. A woman handles all the household finances. She has a stroke. Her husband goes to the bank to keep the mortgage and utilities paid, and the bank tells him it cannot give him access. The money is sitting right there, but no one can legally reach it. Without the right document, the family's only option may be going to court to be named guardian. That process can be slow, stressful, and expensive. So what should you check? Confirm whether you have a durable financial power of attorney and read who you named. People often name someone years ago, then forget. Make sure that person is still the right choice and still willing. Now here is the limitation almost nobody expects, and it is a big one. Having a general power of attorney does not guarantee your bank will accept it. Many banks and financial companies want the document to meet their own requirements, and some may ask you to complete their own separate form. So, a power of attorney sitting in your drawer is not enough. You want to know your financial institutions will actually honor it. That single detail trips up more families than almost anything else, and it leads directly to the second document because protecting your money is only half the picture. The other half is protecting your medical care, and the mistake people make there can be even more costly. The second document is the Advanced Healthcare Directive, and it comes with a companion piece most people never hear about until it is too late. An Advanced Healthcare Directive is a paper that does 2 jobs. First, it names a person to make medical decisions for you if you cannot speak for yourself. That person is often called your healthcare proxy or healthcare agent. Second, it can spell out the kind of care you do and do not want, especially in serious or end-of-life situations. That part is sometimes called a living will. Why do people misunderstand this? Because they assume family automatically has the right to make medical choices and see medical records. In many situations, that is simply not how it works. Here is where the surprise comes in. There is a federal privacy law called HIPAA. It protects the privacy of your medical records, and it can stop a hospital from sharing information about your condition with your own family unless you have given written permission. Think about what that means. Your adult daughter calls the hospital to ask how you are doing after surgery, and the staff may not be allowed to tell her anything. Not because they are cruel, but because the law protects your privacy and no permission is on file. That is why you generally want a HIPAA authorization form alongside your healthcare directive. The directive names who decides. The HIPAA form lets your chosen people actually receive information, ask about your care, and stay in the loop. Do you see the difference? One says, who is in charge? The other opens the door so they can help at all. Now, a warning. Rules for these documents vary by state. In some states, a healthcare proxy already covers access to medical information. In others, having both forms helps avoid delays. So the safe move is having your medical wishes and your privacy permissions clearly covered. Here is the practical result. When these papers are in place, your trusted person can talk to doctors, understand your treatment, and make choices that match your values without a legal battle in the middle of a crisis. Who might not be affected the same way? If you are comfortable and able to make and voice your own medical decisions, you may never need someone to step in. But none of us can predict a sudden illness or accident. That is the whole point of signing while you are healthy and clear-minded. And I want to be clear about one more thing before we move on. There is a separate form for Medicare. Even if you have a healthcare directive, you generally still need a specific Medicare authorization for someone to talk to Medicare about your claims, premiums, and coverage on your behalf. That is easy to overlook. So now you have money covered and medical care covered. But there is still a gap that decides what happens to everything you leave behind. And this is the point I promised you at the very start, the one that protects your money in a way most people get wrong. The third document is your will, and paired with it, something quietly powerful called your beneficiary designations. This is the point that matters most, so stay with me. Why does this outrank the others? Because the first two documents protect you while you are alive. This one decides what happens to your money and property after you are gone, and it can determine whether your family inherits smoothly or gets pulled into a long, costly court process. Let's start with the will. A will is a legal document that explains how you want your property and belongings distributed, and names a person, called an executor, to carry out your wishes. If you pass away without one, you are said to die intestate, and then state law decides who gets what. That may not match what you would have chosen at all, and it can be slow and stressful for your loved ones. But here is the mechanism most people never learn, and it is the heart of this whole point. Certain accounts do not follow your will at all. Retirement accounts, life insurance, and bank accounts with a payable on death option pass to whoever is listed on the beneficiary form for that account. That form can override your will. Read that again because it surprises almost everyone. Your will can say one thing and your account can pay out to someone else entirely based on a form you filled out years ago and forgot. Here is a realistic example. A man updates his will to leave everything to his current family, but his old retirement account still lists a former spouse as the beneficiary from decades earlier. When he passes, that account may go straight to the former spouse, no matter what the will says. The will never touches it. That is why this point matters more than the others. A perfect will can still be undone by an outdated beneficiary form. So what is the correct next step? Do two things. Confirm you have a valid, up-to-date will. Then separately review the beneficiary designations on every retirement account, life insurance policy, and bank account that has one. Make sure each name is still correct. The most important limitation to understand: a will generally only controls assets that do not already have a named beneficiary or a payable on death instruction. So the will and the beneficiary forms have to agree with each other. When they conflict, the beneficiary form usually wins. And the biggest misunderstanding: people think writing a will handles everything. It does not. If you only fix the will and ignore the beneficiary forms, you may leave the most valuable accounts pointed at the wrong person. Here is one additional item worth knowing, though it is not a fourth must-have document for everyone. Some families choose to set up a living trust. A living trust is a legal arrangement that holds your property during your lifetime and can pass it to your loved ones after you are gone without going through probate, the court process for settling an estate. A trust can be helpful for people with property in more than one state, complex family situations, or a wish for privacy, since a will generally becomes part of the public record and a trust usually does not. But a trust is not required for everyone, and it can be more involved and costly to set up. For many people, a solid will with correct beneficiary designations covers the essentials. Whether a trust makes sense depends on your own circumstances, and it is a good question for a qualified estate planning attorney. Here is how to put all of this in order, and the order matters because each step builds on the one before it. First, take an inventory. Find out which of these three documents you already have and pull them out to read them. Many people discover their papers are decades old or name someone who is no longer the right choice. You cannot fix what you have not looked at. Next, focus on the durable financial power of attorney because money problems can hit fast during an emergency. Confirm you have one and confirm your agent is still the right person. Then take the extra step most people skip. Contact your bank and financial companies and ask whether they will accept your document or want their own form on file. Then handle your medical paperwork. Make sure you have an advanced healthcare directive that names your healthcare proxy and pair it with a HIPAA authorization so your trusted people can actually receive information. If you are on Medicare, ask about the separate Medicare authorization form too. After that, review your will and your beneficiary designations together in the same sitting. Compare them side by side so they do not contradict each other. Update any beneficiary form that names the wrong person. Finally, store everything in one safe place and tell your trusted people where to find it. A signed document nobody can locate helps no one. Confirm any legal requirements through an official source or a qualified attorney in your state, since rules vary. Doing this now, while you are healthy and clear-minded, is far easier than trying to fix it during a crisis. Let me clear up the most dangerous misunderstanding around this topic, because it costs families dearly. Many people believe that being someone's spouse or child automatically gives them the legal right to manage that person's money and medical care. In everyday life, it feels like it should, but a bank generally follows its own policies and the law, not your family relationship. A hospital generally follows federal privacy law, not your good intentions. Without the signed documents, love and family ties may not be enough to open the door. There is another trap worth naming. Scammers know these documents give control over money and health decisions. Be cautious if anyone pressures you to sign paperwork quickly, name a stranger as your agent, or keep it secret from your family. Legitimate planning is never rushed and never hidden. And remember the difference between a proposal and a law. You may hear talk about changing rules. Until something is actually enacted, it is not in force. When in doubt, verify through an official source such as your bank, a government website, or a licensed attorney, rather than taking a phone caller's word for it. So let's close the loop I opened at the start. The 3 documents that protect you are the durable financial power of attorney, which lets a trusted person handle your money, the advanced healthcare directive with a HIPAA authorization, which lets someone make medical decisions and actually receive information, and your will paired with up-to-date beneficiary designations, which decides where everything goes. This matters most for anyone who manages their own affairs and wants a spouse or child able to step in without a court fight. And the strongest hidden lesson is the one that surprises nearly everyone. Your beneficiary forms can override your will, so the two must agree. If you do just one thing today, look at what you already have and read who is named. You are not powerless here. A quiet afternoon with your paperwork now can spare your family enormous trouble later. If this helped, consider subscribing so you don't miss the next one.